car crash cases, defective products, dangerous drugs, injuries, and abuse. Across the state of Alabama, the attorneys, proudly sponsored by the law firm of Hollis Wright, are here to serve you. Your tough legal questions answered by our experts. The attorneys with Josh Wright from the law firm of Hollis Wright and host David Lamb.
A good Sunday evening to you. Thank you for joining us here on The Attorneys. We appreciate you making us a part of your Sunday night. Going to be an interesting conversation tonight. Have a fantastic panel of experts ready to take your questions and answer your questions on the subject matter tonight. Just a reminder of how you can be a part of the conversation. You'll notice at the bottom of the screen, all throughout the show, there are ways you can call, text, and email. Please take advantage of those opportunities. But another reminder, there is an attorney actually standing by, so you can speak with an attorney when you pick up the phone and call tonight. So we'd love to have you be a part of the conversation. Leading our conversation, as is most often the case, Josh Wright of the firm Hollis Wright. Good to see you, sir.
You too. Proud to be here this week. Hope we can help some people and answer some questions about employment discrimination and employment law.
Yeah, it's going to be an interesting conversation, this one.
It will be. You know, it's kind of a complicated topic, and when you have complicated topics like this, you want to go to folks that really understand the law. Josh Wright with Wrady and Michel is on with us today. He is a true expert in this area of the law, will do a great job answering questions for us today and for the viewers, and it's a complicated topic. You know, there are some 90,000 people that claim discrimination through what's called EEOC charges, we'll talk about that later, per year. 30,000 of those are based on retaliation nationally, so it's a pretty prevalent and prominent area of the law. And Josh focuses a lot of his practice, among other things, on this. How did you, first of all, welcome, and we're glad to have you on.
Thank you, great to be here.
How did you get into this area of the law? Because it is kind of a specialty.
It is. It's something that I got involved in. I spent a lot of time before going to law school working in different industries. I worked in the construction industry. I worked in the food service industry for a period of time. And I just always found it to be something that I was interested in, that I wanted to make sure that I could help employees understand their rights, protect those rights. Mm-hmm. And like you said, it's a complicated process sometimes, especially under some of the federal laws that exist, the anti-retaliation, anti-discrimination laws. And a lot of times folks don't know what their rights are as an employee. And it was something that just really grabbed my attention when I finished law school. And it was really an opportunity for me to work for the employees out there that are underrepresented a lot of times.
Now, are you and your partner, is this kind of a specialty in focus that you guys have at your practice?
It is. We do primarily focus on employment discrimination, employment retaliation, things of that nature. We also do work for individuals who need their contracts reviewed, things of that nature. We represent folks who are appealing a decision from a professional licensing board. We represent individuals who may be going through the EEO process, who work for a specific federal employer. They will have their own processes that they have to go through before they can really fully preserve their rights in federal court.
Let's kind of start from the start here. I have heard people say for years that Alabama is what's called an at-will state, where people can be terminated for any reason whatsoever. I know there's some exceptions to that, but just explain a little bit about that. And in fact, people probably call your office a lot about, can I be fired for this reason or terminated for this reason? Explain a little bit about what an at-will employee is and how it kind of plays into this whole issue of forms of discrimination and retaliation.
Sure. Generally speaking, if you're an employee in Alabama, unless you are subject to an employment contract, you're an at-will employee. And what that means essentially is that your employer can end that employment relationship for a good reason, bad reason, no reason whatsoever. And what I like to tell folks when they call in and they have an issue sometimes is, you know, your employer can literally just go ahead and cut ties with you because of the color of your shoelaces or the shirt you're wearing. There doesn't have to be a good reason. Sometimes folks understand that, they're kind of familiar with it, but a lot of times people are unaware of the fact that in Alabama you can literally be terminated for any reason. The laws that we work in and that we focus on at our firm really are the exceptions to that general rule. And that's where the anti-retaliation statutes come into play in state and federal law.
And when we talk about discrimination and retaliation, are there certain types of protected classes of folks that you can't discriminate against for these reasons? Does that make sense?
Sure. There are, and one of the laws that Congress enacted back in the 60s is called the Civil Rights Act of 1964, Title VII of the Civil Rights Act of 1964. It's been amended, but essentially there were some classes, protected classes that were carved out that an employer cannot discriminate against you for, such as your race, your gender, your disability status, your age, your national origin, your religious affiliation. Those are some of the big ones that they really focused on. And again, that's federal law. There are other exceptions to the general rule. That's the one that really kind of focuses on discriminatory acts and things like that. Under state law, one of the ones that we see a lot of is an individual being retaliated against for filing a workers' compensation claim.
What are there other activities or actions that people, if they engage in, are protected from employer retaliation?
Sure. One of the main things that we will look for when someone calls our office and they've been terminated is, well, what exactly led to that termination? Mm-hmm. Were they an individual that engaged in a protected activity such as going to human resources and reporting that they were being discriminated against, reporting that they were being harassed by another employee? Did they report that their pay was not up to par with other individuals outside of their racial class? Things of that nature. When you're comparing apples to apples, same position, but differences in pay. If an individual has taken that action and engaged in that protected activity, well, then that can set up a claim for retaliation later. Another way that an individual may engage in a protected activity is to go and file an EEOC charge with the United States Equal Employment Opportunity Commission.
That was the issue that I mentioned at the front of the show, which is there are some 90,000 EEOC complaints that are filed per year, and 30,000 of those are roughly retaliatory-based issues. And so, that's a whole process in and of itself that has certain deadlines, and you have to file your EEOC charges in order to protect certain rights within a certain time frame. If you think you've been discriminated against, there is no question that one of the things you need to do is get with counsel like Josh, who know this law, to make sure you meet your deadlines, meet your obligations of reporting and doing the things that you need to. One of the things I do want to talk about, and I'm not sure if we're going to commercial break or not yet.
3 minutes.
All right. One of the things I do want to ask is this, and this is kind of an important issue because I get it a lot, and that is, if I think I'm being discriminated against in the workplace, what do I do? And that's kind of an important starting point, I think, for someone that feels like, as they sit here watching tonight, I'm
Sure.
being discriminated against. What do they do? What are their obligations?
Well, the first thing to do is to act quickly, because like you said, the statute of limitations on these issues are very short. You have 180 days from the date of the last discriminatory or last retaliatory act to file an EEOC charge. And you can go about reporting the discrimination in one of two ways. You can either keep it in-house, and you can go to, you can go up your chain of command, you can go to human resources. If you're going to do it that way, make sure that you document it in writing, and make sure that you create a paper trail. You don't want to do it verbally. You don't want to report the harassment or discrimination just in a conversation to human resources. You want to make sure you send an email, you send a fax, something like that, so that it doesn't come up missing and later on they claim that they never received that reported discrimination or harassment. Another thing, if you're going to report it that way, make sure that you find your employee handbook and make sure that you take a good look at what the procedures are. Otherwise, you can set up defenses for the employer later.
I'm going to let him finish this after we get out of commercial break, but one of the things I do want to talk about when we get back, David, and I think it's important, is discrimination just doesn't come in direct discrimination, meaning direct comments and solicitations, etc. A lot of times it comes masked in other ways, and I know Josh will be able to give us some examples of things he sees in the workplace that is actual discrimination that may not be so direct.
Right. All right. We'll dig into that when we come back. A reminder as we head to break how you can join the conversation, call, text, email. Would love to have you be a part of the conversation tonight. Also a reminder, you can find the firm of Hollis Wright if you search that term on Facebook, and on Twitter it is Hollis_Wright. Stay tuned. More of The Attorneys coming right up.
I'm Josh Wright with the law firm of Hollis Wright, and thanks for watching The Attorneys on Alabama's 13. Now, we hope you, a friend, or a loved one never need legal counsel for a case. But if you do, the goal of this show is simple: provide answers and legal counsel when you need it the most. Your call to the show is free, so if you have questions specific to this show or related to other civil legal matters, call, email, or text us to talk with one of our lawyers. You can also follow us on Facebook or Twitter to learn about important legal news that could affect you or your family, or simply contact us by going to alabamas13.com and click on the attorney's link. Now, we know your time is valuable, so thank you for spending it with us and for watching the attorneys right here on Alabama's 13.
Busy there.
Yeah, trying to document that stuff, no question.
Man, all right. Welcome back in to the attorneys. Appreciate you being with us. A reminder at the bottom of the screen, ways you can join our conversation tonight. You may have faced some form of discrimination or you want some questions answered. Now is your time to get those questions into us. We'd love to take them. Josh?
That's a perfect intro, David, because one of the things I wanted to talk about after break was, you may have been discriminated against. Discrimination doesn't always come direct in your face. Sometimes it is, and I know you see this in your practice, it comes in a lot of different colors and flavors. Is that accurate? And what are some things that you see that people need to look for to make sure that if they're being discriminated against, that they can be protected?
Absolutely. There are really two types of evidence that we look for. We call the first direct evidence, and the second is circumstantial evidence, and I'm sure most people kind of have an idea of what circumstantial evidence is. Direct evidence is essentially that smoking gun evidence that we retaliated against this person, we terminated them because they filed an EEOC charge or because they reported illegal discrimination or harassment, or we terminated them because of their race. Someone is either willing to come out and say that and they speak for the company. There's an email out there, something of that nature. That's direct evidence, and really what that does from an attorney's perspective is once litigation has commenced, it makes it a lot easier to get the case in front of a jury. Those types of situations are very rare. It's very uncommon that someone's going to slip up and send that email. Right. There may be several people talking about it, and that may be what the goal is, but it's just not common that that's going to be the type of evidence that we bring a claim on. So what we generally have to do is piece together what happened through looking at all the circumstantial evidence. And some of the things that we might see would be, let's just say, for instance, someone went and reported illegal discrimination, harassment, based on their gender, their race, or they're disabled, something of that nature. And suddenly they're being burdened with an excessive workload. They're simply given too much work to be able to complete in the amount of time they're being provided to complete it in. And another thing you might look for is a reduction in hours in conjunction with that excessive workload. Mm-hmm. That's something that we oftentimes will see negative comments toward the individual from folks in management that they're clearly not happy about the fact that that person is gone and exercise that protected activity, basically treating them like they are kind of an outsider. They're not a team player, that sort of thing. You might look to see whether or not their pay has been reduced. All of these things can be adverse employment actions in and of themselves, but at the same time, it's also just simply probative of whether or not you're being retaliated against.
Josh, talk just for a second about this issue too. The law protects not just those that have been discriminated against, but those that report discrimination that are retaliated against for reporting that discrimination. The law also protects those people, do they not?
That's absolutely right. You can bring a claim with the United States Equal Employment Opportunity Commission, otherwise known as the EEOC, for discrimination. You can also bring a claim simply for retaliation. If you have reported internally to your company that you believe you're being discriminated against or harassed, and within the appropriate amount of time you bring an EEOC charge after having been terminated or suffered some other form of adverse employment action, you can then just bring a claim with the EEOC for retaliation. We deal with just our claims that are simply just retaliation claims on a regular basis.
Speaking of the EEOC and that process, some questions here about that. How cumbersome, how complicated, what does that process look like?
Well, Generally speaking, when someone has a legal cause of action, they have one statute of limitations that they have to be concerned with. And you'd know better than me, Josh, but typically that's 2 years or more, right?
Yeah.
In this case, you have 180 days from the date of the last discriminatory act or the last retaliatory act to file your charge with the EEOC. Once that charge is before the EEOC, a couple of different things will happen. Initially, the EEOC will attempt to provide both sides with an opportunity to mediate that claim. They will mediate that on behalf of both sides free of charge. They're excellent mediators over there at the EEOC. Sometimes it works out that way that the claim is resolved when it's in the EEOC's hands right there. If EEOC mediation is unsuccessful, or if one side is uninterested in mediating the claim, it'll then be assigned to an investigator. That investigator then requests that the employer provide a position statement or a response to the allegations claimed in the charge. That process can take anywhere from a couple of months to a year and a half. The EEOC investigators are very good about getting statements from witnesses, collecting the facts, which actually down the road, if you do file the claim in court, makes the litigation process a little bit easier. You have to provide the EEOC with at least 180 days before you can request that they dismiss your claim and get what's called a right to sue notice.
Go ahead. I'm sorry, I didn't mean to interrupt you.
Once you have that right to sue notice, you basically have your ticket to get into court.
Okay.
You can go ahead and you can file your lawsuit in federal court, but you have to do it within 90 days. So there's your second statute of limitations.
All right, so two issues that come up that I want you to talk about quickly. One is if you don't get a right to sue, if they deny your right to sue, you still have the potential to file your federal claim, do you not?
Well, they will always issue either a right to sue or they will keep the case themselves and they will initiate litigation. Okay. It's very rare, though, that the EEOC is going to keep your claim and initiate the litigation on your behalf. About 95 to probably 96% of the time, you're going to get a right to sue notice.
And I know there are viewers watching right now that are saying the last form of discrimination that I faced at my past employer, whatever, is longer than 180 days, but it's within a couple years. They have the right under certain state claims to pursue state law claims, even if they didn't file their 180-day EEOC claim. Is that accurate?
That is accurate. It's claim specific. For instance, under Alabama law, you can bring a claim for invasion of privacy if you believe that you've been sexually harassed. There is not a separate federal law that you could proceed under other than Title VII for sexual harassment or sex discrimination. With respect to race discrimination, there is a separate federal claim that is, it's 42 U.S.C. 1981. It's essentially race discrimination in the making of contracts. You can also bring a claim of retaliation under that law as well. Yeah,
I want to talk a little bit about retaliation and the difference in retaliation and general discrimination when we get back. I think it's important for people to understand the distinction between the two.
All right, we'll take a break right there. As we step aside, a reminder of how you can speak with an attorney standing by right now. Just pick up the phone and call the number right there. You can also text or email if you would rather. Stay tuned. The final segment of The Attorneys coming right up.
I'm Josh Firth with the law firm of Hollis Wright. Most of us have either been involved in or we know someone who's been involved in an automobile accident. Sometimes the police will issue a ticket if one party is at fault. But what about those times when a ticket is not given? In tonight's Legal 411, we're answering the question, who is responsible when no ticket is issued? Just because there is no ticket does not mean there is no liability, especially if someone is injured in the crash. First, it's important to understand the law. Did you know that unless an officer personally sees the crash, he can't write a ticket even if he is certain the other person is at fault? There are two exceptions to this rule. One, if someone is driving under the influence, and two, if someone doesn't have proof of insurance for their vehicle. Even if a ticket is issued, that is not a guarantee of liability or that the injured party will win the case in front of a jury. However, a jury may find a person liable for negligence if the person at fault was driving improperly or violated one of these 6 rules of the road. For example, driving without proper taillights, texting or talking on the phone, improper lights or signals on a trailer, failure to yield to oncoming traffic, hitting another car from behind, or changing lanes improperly or without signaling. Any of these can serve as a basis for a jury to find someone negligent for causing an accident and injuring another person or their property. So the person who caused the accident is ultimately responsible for the injuries, even if the police officer does not assign fault. But you have to prove liability. That's why it's so important to ask for legal guidance if you are ever injured in a crash. Please remember, your call, email, or text to the attorneys is free. All of us at Hollis Wright want to help answer the questions you face on real issues every day. And remember, a competent lawyer will respond to every question you send in. That's our pledge and promise to you. Thank you for watching The Attorneys on Alabama's 13.
Knowing your rights. It's a lot of what is covered often here on The Attorneys. Welcome back. This is the final segment. Just a few minutes remaining. Call, text, email, join the conversation. We would love to have you do so. The firm fact there, talking about retaliation under the workers' comp statute. If someone feels like they're being retaliated against for filing that, do they have a case? Do they have a claim?
They absolutely can. A lot of the things that we've talked about with respect to the federal laws and protecting yourself against race discrimination or sex discrimination, harassment, similar analysis applies to that situation. If you filed a claim for workers' compensation benefits or instituted or maintained a claim for workers' compensation benefits, and you were retaliated against in the form of termination, then you can absolutely bring a claim for workers' comp retaliation under Alabama state law.
A lot of times, kind of outside the realm of this discrimination, you know, we've done shows on the FLSA and overtime wage violations. A lot of times we tell people that the retaliatory component to that statute is worth more to you as an employee. So if they terminate you because you reported an FLSA violation or an overtime violation, that retaliation claim is worth more than the actual original claim itself. Right. And the same thing works in these cases too, that a lot of times these retaliation claims are worth more from a financial perspective for the employee who was, for example, terminated, laid off, whatever, than the underlying retaliation itself would have been, or excuse me, the underlying discrimination would have been. And that was one of the questions I wanted to ask you. I am sure there are things that you see in your practice that fall far short of being able to be successful in a discrimination case, but still may serve as the basis of discrimination, and that you have to kind of counsel people through that this is not worth bringing, but yes, you may have been discriminated against. I mean, do you see that kind of stuff?
Sure. Something that we see a lot of will be comments that are made. Individuals that you work with, maybe they're in the cubicle next to you or in passing, what have you, they may make comments that are just simply out of line. They may ask questions about your personal life that they shouldn't be asking. They may make comments about your race, things like that. We get a lot of calls about that, but what rises to the level of being what is known as a hostile work environment is something that you have to have essentially that happening on a daily basis, where it's gotten to the point where it affects your terms and conditions of your employment. For a hostile work environment claim to exist, and they're similar whether you're talking about sex discrimination or race discrimination, but to have one of those claims that's going to be able to have any success in court down the road, it's going to need to be severe pervasive treatment. And by pervasive, we're talking about it's permeating the workplace essentially. We do receive a lot of calls where it just doesn't rise to that level. There's a lot of case law out there that kind of gives you an idea of what does rise to that level and what doesn't.
What do you see most often in your practice? I mean, I'm sure the stuff trends. It changes from year to year. What kind of stuff are you seeing right now that's pretty popular?
Right now we've been receiving a lot of calls on workers' comp retaliation claims. Okay. And like you said, those are claims where the amount of recovery can be a lot more substantial than the underlying workers' comp claim, especially when you're dealing with workers' comp, because it's we're talking about statutory recovery amounts with the workers' comp injury. But with workers' comp retaliation claims, you can receive compensatory and punitive damages. And sometimes that can be substantial.
We had a circumstance at our firm about 6-7 years ago where we had a vendor that came in that had made some inappropriate comments to an employee, and it's something we had to deal with, and we did. We resolved it. Do you see that, and is that any form of discrimination?
An individual who's being targeted with sexual harassment, comments that are constant, consistent, if that vendor's coming, to the office on a regular basis, and that person's being targeted by that individual, the employer of the targeted employee does have an obligation to protect that person from that, and there have been claims that have been brought on that basis. You have to have, obviously, an absolute degree of neglect on the employer's part.
Yeah, lawyers sometimes hire lawyers to help answer questions for them, and that's what I did during that time, because candidly, I didn't know the answer to it. I did not know what our obligations were, and we got some very good advice, similar to what Josh just mentioned, that we needed to resolve it, and we needed to make sure that it ended, and that's what we did. And so at the end of the day, a lot of times you want to go to somebody when you've got these issues that knows what they're doing. Well, our firm may not have any knowledge of that, but Josh's firm does, so we go to guys like Josh to answer those questions for us.
Just less than 2 minutes remaining.
Sure.
I want to give both of you all a chance. Just a final thought. What do you want to leave the viewers with tonight?
Well, the main thing that I would want to leave the viewers with is, if you feel like you've been discriminated against, or you feel like you're being harassed, if you feel like someone's crossing the line at work, you need to do something about it, and you need to do something about it quickly. You need to either go to your human resources department and report the harassment and discrimination the way we talked about earlier, make a paper trail, keep notes about what's going on, that sort of thing, and make sure that you've got it on the record that this is happening. Because like I said, you only have 180 days really to bring an EEOC charge. Right. If you don't feel comfortable going to your human resources department or taking it up the chain, so to speak, go directly to the EEOC.
Right.
Very quickly, I would just say, if you forget about Josh's firm after tonight, we're on every Sunday night. Call us and we will get you with Josh's firm, because this is such a specialized area with such tight time frames. If you are a viewer out there that has been involved in a form of discrimination in any respect, you want to get to a lawyer quickly. You do not want to let this sit. You need to make sure that you do the things that you need to protect yourself, to ensure and maintain you've got a claim. And that's where guys like Josh and his law firm come in to be able to lead, guide, and direct people through this process.
Great advice, great show, gentlemen. Thank you both for being with us.
Thank you.
Thank you for being with us as well. We appreciate it every single Sunday night when you are here as we wrap things up. Here's how you can continue to get in touch with the firm of Hollis Wright. Find them on Facebook and Twitter as well. We appreciate you being with us, and we'll look for you next week right here on The Attorneys.
Thanks for watching The Attorneys, sponsored by the law firm of Hollis Wright.